a very pervasive role in the decision making, both by at first instance and in the tribunal. The term is bandied around quite a lot. It's used in relation to particular elements of the applicant's story. The story in its totality, the credibility of the fear, and the credibility, the personal credibility of the applicant. I think all those raise issues not just of technique, that's to say handling medical evidence in the sense that story is inconsistent, or you could respond, well, we could be very careful pointing to inconsistencies in stories presented by people who've suffered trauma. But I think it's not just about medical evidence. I think it's about disaggregating the forms of reasoning and the applicable law relevant to a rather peculiar thing, proving a risk. It's in fact almost tautologous. So we're going to do that before we get on to the UK law and policy. Okay, so I'm just going to develop one point really in relation to the UN handbook. This is its discussion of the interpretation of subjectively well-founded fear. As you can see from the quote, it says that due to the importance that the definition attaches to the subjective element, an assessment of credibility is indispensable, and I've added the emphasis here, where the case is not sufficiently clear from the facts. Now, the point here is that proof of facts is a binary conclusion. They are proven or not to a required standard. But credibility here is an alternative to proof. It's what happens when you can't prove something. So I'll say for the first time in the presentation at this point that establishing credibility should not be a binary conclusion, yes or no, true or false. But I'm going to keep coming back to that point. The UN handbook also mentions credibility in relation to the objectively well-founded fear. But this is also, if you sort of read the UN handbook, only relevant when facts are not proven. Okay? So, certainly relevant, but it's not the starting point. It's only relevant when the facts aren't proven. But, nevertheless, credibility will play a role. My point is, it's not always necessary to call on credibility. I think that's much clearer on the next slide. This is in a section of the handbook on establishing the facts, principles, and methods. Okay, so there's a little bit here about how you might approach the decision-making process. Relevant facts will have to be furnished in the first place by the applicant himself. Fair enough. It then falls upon the person charged with determining the status to assess, and look, there's two separate things here, to assess the validity of any evidence and the credibility of the applicant's statements. This is the second bit of advice from the UN on benefit of the doubt. The point here is the applicant's general credibility is not the starting place. Forgive me for thinking, having read plenty of UK decisions on this. It's to help us when the facts are not proven, but where the story is credible. And as I've said, credibility is a substitute, not a synonym for proof. On the second part of the quote here, the way I read it, in conjunction with what we just had seen on the previous slide, is that the UN is saying that the applicant's statements that are not susceptible to proof must be coherent and plausible, etc. Which is fairly straightforward, you would expect that. So, summarising the UN approach, credibility is about the benefit of the doubt, first and foremost. It's not a starting point. It's a substitute for proof of past events. Credibility is not a binary conclusion, yes or no, conclusively. It's a substitute for that sort of proof in situations when the statement is simply not susceptible to proof. Let's turn now to UK law and policy. This is another one where I'm just trying to be thorough. Okay? As you all know, the 1993 Act is the first dedicated piece of immigration law on asylum in the UK. It's quite recent, but that's the first time it gets an official mention. Before then it was done solely by the executive. In paraphrasing the Quran case, evidence about which you're certain should be taken into account. Evidence that's probably true, but you're not certain about, should be taken into account. It also says, Quran that says, and the API, so you've got to take into account evidence to which you're willing to attach some credence, which read credible, but which you're not willing to say is probably true. Now, that's quite an interesting set of considerations to have to take into account. The only thing, according to both Quran and the API, that a decision maker is allowed to not consider is evidence to which they are not willing to attach any credence at all. Okay? So far so good.
I think it's quite clear that we need to take the politics out of the process for deciding who deserves asylum. Otherwise, we will always be left with a situation where the people who are the government department responsible for keeping numbers down, keeping the system, keeping the borders shut, keeping British jobs for British workers, are also determining asylum claims, are fighting those claims, and often those claims don't even get to court for a second opinion, as was highlighted earlier. The speed of the process and the lack of access to lawyer means that sometimes that's people's only shot. It's a Home Office decision on their case, and they don't get to challenge that, or they don't have the right to challenge that if they have a non-suspensive appeal process applying to them. So we need to ask for an independent system. We need to challenge destitution, and we need to suggest alternatives, and an obvious alternative is the right to work. And we're running a campaign through the Refugee Council that's supported by the TUC, which we're hoping to launch later this spring, to up the demand for the right to work. I think we also need to challenge and ask the government to do something instead with this 5-year limited leave. So refugees now get 5-year limited leave once they're recognised as having a case to stay in the country. They used to get indefinite leave to remain, they don't now. So in 2009 we'll start to see the first cases come through of this 5-year limited leave status, which to me is the cruelest thing you can do to someone, is put them through an asylum process, recognise them as a refugee, and then say that their case is subject to active review by the Home Office. The Home Office thinks the situation in your country is improved enough for you to go home, they can tell you to do so, and they can review your case after 5 years and decide whether or not you still need status. I don't actually think they'll ever get around to doing it. I don't think that they have the mechanism. I don't think they've thought about the legal challenges that would happen. But the threat is there, and the policy is there, and it affects people's lives because they get status for 5 years. So it means it's harder to get jobs, it's harder to access social housing, and it's harder to just rebuild your life because you have this thing looming over you.
In 1996, benefits for all in-country asylum applicants were medial, and there were staged phases to it all. Benefits were refused to in-country asylum applicants. From one day to the next, you had a situation where, when you did not know whether or not your neighbour was black, white, British, black British or white British or Eastern European or African, you suddenly knew that they were probably an asylum seeker. They suddenly had great needs. I remember working with the National Coalition for the Anti-Deportation Campaigns, and we were leafleting at that time, and we had a big demonstration. That was the days when we had the Tories, so you could have demonstrations on immigration policies. And we said there's going to be an increase of racism because of these policies. What subsequently happened was that the lawyers basically used the 1948 National Assistance Act to force a requirement on supporting asylum seekers on local authorities, certain kinds of asylum seekers, so asylum seekers who were destitute and had an additional need. Then subsequently in 1990, the government also imposed the national asylum support system, okay? And that as well resulted in two things. Sorry, I'm going ahead of myself. In 1999, the support system was actually reacting to a sudden demand at local authority level for services. Local authorities were having, in Kent and in London, were having to basically bail out asylum seekers and provide support under the 1948 Asylum Support Act, National Assistance Act. So in 1999, the Asylum Support Act was a decision to disperse asylum seekers, to share the burden throughout. Throughout this time, with mass support being introduced, and just before